Okay, so good afternoon again. Thank you for joining this FOIA training, which is the first in the Office of Open Government's FOIA Training Summer Webinar Series. My name is Joan Lelma, one of the attorney advisors in the Office of Open Government. If you have questions, please place them in the chat. One of my colleagues will respond, or I'll answer at the end. If you'd like to ask verbally as well when I'm through with the presentation, that's fine. And so, as most of you are aware, the Office of Open Government is led by Director Nickel Allen, Chief Counsel is Lois Neal, Attorney Advisor Anthony J. Scarborough, and our trial attorney is Brandon Lewis, Paralegal Specialist Kimberly Brown, and IT Specialist is Kevin Brown, and Kevin serves both offices, the Office of Open Government and the Office of Government Ethics. The offices are within the Board of Ethics and Government Accountability. This is what we will cover this afternoon, our introduction, and then some basic exemption reminders, what agencies get wrong, asserting an exemption, and no information found simultaneously. What agencies get wrong continues, and so we'll be looking at Exemption 1, Trade Secrets, Exemption 2, Personal Privacy, and Exemption 4, Agency Communication. Or introduction. What's the purpose of FOIA? FOIA facilitates government transparency and accountability. It provides a means for the public to know about the affairs of the government and permits agencies to protect certain records that fall within any of the FOIA exemptions. So that's openness and transparency. The Freedom of Information Act, DC FOIA, is codified at DC Official Code sections 2-531 to 2-540. The exemptions are at 2-534. Application of federal FOIA to DC FOIA. DC FOIA is modeled on federal FOIA. And what does that mean? You can look to federal FOIA to make certain determinations under DC FOIA. And there is a case we'll get to a little bit that states as long as there is no inconsistency with the two statutes. And so in this case, Barry against Washington Post, per curiam, the court states many of its provisions closely parallel those of the federal act. And so as a result, you'll see that some of the cases that we examine this afternoon are federal cases. The decisions construing the federal statute are instructive, and they may be examined to construe the local law. And there are two cases here on point. And now this is the Court of Appeal statement that except where the two acts differ, we have treated case law interpreting the federal FOIA as instructive authority with respect to our own act. What's the general presumption under FOIA? Disclosure. DC Official Code Section 2-531. DC FOIA must be construed with a view toward expansion of public access and the minimization of costs and time delays to persons requesting information. And this case, the Court of Appeal in Barry deals with the presumption. The court states, like federal FOIA, the local FOIA embodies a strong policy favoring disclosure of information about governmental affairs and the acts of public officials, a policy which requires the courts to read narrowly any statutory exemptions from disclosure. And so while the statute permits withholding certain information, agencies must construe them narrowly. What is an exemption? A FOIA exemption is a statutory provision that gives a government agency the authority to withhold certain government agency records or information from public disclosure. And for ease of reference, there's a link here to DC official code. Let us go through some basics. There are just some reminders, 4 of them. The first is correct application of FOIA exemptions must not be thwarted by any appearance of embarrassment, but beware of more than a de minimis privacy interest. And what does that mean? Okay, so information that seems as though if it's a link to an individual, it will be embarrassing. However, there is no individual who the information is linked to or is likely to be linked to. And so in those situations, the information, they're standing alone without any personal link. One would want to lean toward, because of that embarrassment factor, withholding. But we have to be careful because if it's just merely that no other exemptions apply, and we have not established that more than de minimis privacy interest, then we do not have a ground for withholding. And likewise, I put but here, underlined, because when we get to examining privacy interest, personal privacy, we'll look more that on both sides, we have to be cautious because we don't want to release personal identifiable information as well. The second basic reminder, feelings or emotions must not take precedence over the correct application of FOIA exemptions. And we'll explain as we move along. 3, convenience must not trump the correct application of FOIA exemptions. And 4, exemptions and correspondingly redactions, when we are not withholding in full, then it means that there will be some redactions, must be applied consistently. The first, an exemption must not be applied to withhold records releasable under DC FOIA because its release would be embarrassing if linked to an individual. But note that there is no link and there's no likelihood of link. And of course, we say beware of more than a de minimis privacy interest. We'll get into that as we move along. The second one, an exemption must not be applied to withhold records releasable under DC FOIA because it feels like the right thing to do. FOIA officers must always err on the side of caution when releasing records, but valid statutory reason for withholding must always be in contemplation. And I have here, remember, foreseeable harm. And so foreseeable harm is not built into exemption 4 so much, which is the federal exemption 5. And so that's one of the exemptions where it's applied, not built into, but it's applied. And so as we move along, we'll be able to explain more about this. And so you might be saying, well, I know all of this, so that's why we've started with the basics. The fourth one, an exemption must not be applied to withhold records releasable under DC FOIA because it's easier, more convenient to redact a large area than to correctly redact all the portions throughout the document. And so you have this large volume of records, and it's tedious to go through line by line, and certain information you have to be redacting because You have your responsive, releasable information, and it's so close to the information to be withheld. Exemptions apply. And so while it would be faster, it would be more convenient to go ahead and either withhold the entire document or to redact a huge portion that contains releasable information. And so just a reminder, take your time. It's time consuming most of the times, but just go through and do what is correct. Apply the exemptions accordingly. Incorrect use of exemptions. Another one, I thought it was at the last reminder, but there's another one here. Exemptions, redaction must be applied consistently. Duplicate documents must have the same exemptions applied. Therefore, if redactions are done, the documents must bear the same redactions. And so it's not a haphazard kind of redaction process. You have the same documents, you're going to treat them, copies of the same document, you're going to treat them the same way. So it's the requester must not receive one document redacted a certain way and then receive a duplicate with different redactions applied. So consistency. What agencies get wrong: assert an exemption and issue no information found response simultaneously. And this one I have not, if you notice, I have not put a exemption to it because it goes across the board. It affects all the exemptions. And so you must not apply any exemption if your research yields no responsive record. So where there are no responsive records, your response must be an NIF. And we have a matter here on point from the Mayor's Office of Legal Counsel, the MOLC 2024 appeal. The MOLC states in its appeal decision that the agency has asserted an exemption, but also explained that it was unable to identify any responsive records. To resolve any ambiguity as to whether the agency was unable to identify any responsive records or whether responsive records exist but were being withheld under DC official code, a remand is appropriate. And so you want to save yourself time. In that regard, you have a NIF, easy way to go. Do your letter accordingly. Do not put or mix exemption with an NIF in your response for the same document or same request. I should say sometimes depending, it can be same request or it can be same document, because you can have a request that covers a wide range of documents and depending on what the response states. But the heart of the matter is that you must not apply exemption and NIF together. What agencies get wrong? Exemption 1. And so we are going into the specific exemption, attributing that one was across the board. And this one is as it relates to exemption 1. Completely ignore all the requirements of the exemption. Mischaracterize releasable information closely related to correctly withheld information, and overbroad use of commercial and exceed definition of trade secret. Exemption 1. It protects trade secrets and commercial or financial information obtained from outside the government to the extent that disclosure would result in substantial harm to the competitive position of the person from whom the information was obtained. So our keywords, you'll see us looking at these, going through trade secrets, commercial or financial, and substantial harm, competitive harm or injury, as stated in some of the cases. DC Official Code Section 2-534A1. The federal equivalent is Exemption 4, covers trade secrets or commercial or financial information that is confidential or privileged. And when does information provided to an agency qualify as confidential? We have the answer from a well-known Supreme Court case, Food Marketing Institute against Argus Leader Media. The Supreme Court held that information is confidential and protected if the information is customarily kept private or at least closely held, and where the receiving party provides some assurance that the information will remain secret. And so there are two aspects, and of course, if we should get deeper into it, then we'll see that there are certain yes, no, as you go ahead to make that determination. But these two, they are your bright line to start with. Commercial or financial. DC Circuit instructed in Public Citizen Research Group that the terms commercial and financial use in federal FOIA should be accorded their ordinary meanings. And we will see from a recent circuit court case that, how it deals with commercial as well. So we'll see that the court is staying in line with previous decisions. How about foreseeable substantial competitive harm? Exemption 1 has been interpreted to require both a showing of actual competition and a likelihood of substantial competitive injury. And there's a recent case, the same case I'm referring to, that covers all these prongs, these different elements. So we will, a CDC case, we'll see how the court has handled confidentiality and competitive harm. What agencies get wrong: completely ignore all the requirements of Exemption 1. And yes, sometimes this happens, and I say completely ignore. It's not a matter always of not making that effort, because we'll see from cases that, of course, agencies always put forward a reason, albeit it doesn't hold muster some of the times. It doesn't accord with a statute. It doesn't accord with any precedent. So this term, thrice not clearing the hurdle. So missing the mark 3 times. And the first one is confidentiality. The second is failure to establish that the information is commercial or financial. And the third, failure to establish foreseeable substantial competitive harm if the information is released. The case that I mentioned earlier is this America First Legal Foundation versus Centers for Disease Control, CDC. And in this case, it was found that the defendant failed to clear the hurdle in one instance 3 times. So not showing confidentiality, not showing substantial competitive harm, and also not showing that commercial aspect. So the plaintiff disputed the non-disclosure of all Exemption 4 withholdings related to BrandLift, which is an advertising measurement platform, and CrowdTangle, which is a social media analytics tool, both devised by Meta Platforms. The defendant prevailed concerning BrandLift related records withheld under Exemption 4, but the court found that the defendant incorrectly withheld CrowdTangle related information under the same exemption. And it's 3, as we have stated, hurdles that were not clear. And so we must always bear those in mind. First, you look at the confidentiality, then you look at the commercial aspect of it. And then when you have established those, you get to the foreseeable commercial harm. Exemption 1 continues. What agencies get wrong? Overbroad use of commercial. And I've used the same case to demonstrate. The defendant stretched the use of commercial beyond its limits by deeming Crown Tangle's information as commercial and contended that the records were commercial because the reports were created by Meta in the regular course of business, and that the reports further Meta's business goal of offering its users a safe and enjoyable platform. And so this is very vague. This is overbroad. And, the court says that just about anything then submitted to the government in such a case, if that was a standard, would qualify for protection under Exemption 4. And so that is something we must be looking out for your officers, those who are conducting reviews, ensuring that the meaning of commercial is kept in contemplation, and it's not just a broad catch. The defendant stated that, as we've read over here, they created by Meta in regular course of business. Businesses create, entities create all sorts of records in the regular course of business, but that's not the standard for FOIA for the exemption to apply. Continuing on with Exemption 1, what agencies get wrong. Another is mischaracterized releasable information closely related to correctly withheld information. And this is a lot, so let us break it down. Mischaracterized releasable information. And so those information are not protected under FOIA, but they're closely related to correctly withheld information where the exemptions are properly applied. And the close relation can be in many ways. It can be the same custodian, can be created around the same time, the same subject matter. And I'm using the same case, but the mischaracterization here in this particular case, it's on the part of the plaintiff that the court used that word, but it also goes to the defendant to a certain extent, as we'll see. But let us start off with the plaintiff first, aspect of the plaintiff's mischaracterization. So if the information is customarily kept private or at least closely held, and the receiving party provides some assurance that the information will remain secret, the information must be treated as such, notwithstanding information on the same documents or attachments that do not meet the Argus confidentiality threshold. And so this is as it relates to the plaintiff. So you do the reverse for the defendant, whereby yes, you have information there that will be withheld, but you also have releasable information. And so you're not going to mischaracterize just to withhold all of the records. Continuing on with mischaracterization, confidentiality. The circuit court found in this American Legal Foundation case that the plaintiff mischaracterized documents that were confidential and customarily held private, and where assurance was given by the government that the records would be held confidential. And see, the prongs, they have been satisfied. Customarily held private, assurance given by the government. And so the explanation here, the court found that the agency, and I'm quoting, withheld only portions of the brand lift reports that would reveal information like estimated dollar figures for ad pricing, discussions of brand lifts, test budget terms, offerings and recommendations, and partners account numbers. And so these, even though these information, these records, they were among other related records, these are covered under a FOIA because you can see just by looking at them test budget terms, offerings, partners, account numbers. And plaintiff, the court states that plaintiff reasons the reports are not confidential because Meta willingly put them on sale or any paying customer would access them. And the court found that this argument mischaracterizes the defendant's withholdings, meaning that there are other documents that will not or were not withheld or could not have been correctly withheld under FOIA, but that does not detract from these documents where the FOIA, the exemption, applies properly. So as it relates to CrowdTangle, their reports were found not to be confidential. The defendant CDC asserted that the reports were not available publicly because users had to meet specific meta access requirements before they could use that CrowdTangle function. However, the court found that Meta provided access, precluding a finding that the reports constituted only limited disclosures, such as to suppliers or employees. And so this is mischaracterization in a sense. The court did not use that term as it relates to the defendant, CDC. And it's also definition, the way that we looked at the definition of commercial, this is also stretching the definition of confidentiality in a sense. So you can see mischaracterization as well as stretching what confidentiality means. And so under exemption 1, another thing that agencies, another step that agencies take sometimes as it relates to applying exemption 1 is to exceed the definition of trade secret. What constitutes a trade secret? A trade secret directly relates to the production or manufacturing process. And so you address your mind to, is this the process? What is taking place? Is this the product? Is this, some feature of the product? Information relating to the finished product, such as its features and performance, are not trade secret. And the court in Public Citizen Research states that trade secret is a secret commercially valuable plan, formula, process, or device that is used for the making, preparing, compounding, or processing of trade commodities that can be said to be the end product of either innovation or substantial effort. We're on to exemption 2. Personal privacy information of a personal nature where the public disclosure would constitute a clearly unwarranted invasion of personal privacy. Under federal equivalent, exemption 6 covers personnel, medical, and similar files, the disclosure of which would constitute a clearly unwarranted invasion of personal privacy. And the court has found that similar files is not as restricted as some thought at first blush, but it covers all the records, but you must be able to make that connection to an individual. So it's not limited to personnel and medical files or documents. inability to balance individuals' privacy interests with the public's interest. That is one of the steps or instances of wrong application of the exemption. Inability to balance individuals' privacy interests with the public's interests. And Department of Justice, this Reporters Committee case, has given us the standard which requires that the government balance the individual's privacy interest against the public interest in disclosure. The FOIA officer must perform the balancing test under this exemption. Of course, the individual's privacy interest in the material is at issue must be balanced against the public's interest in disclosing, and this public interest must serve the core purpose of shedding light on an agency's performance of its statutory duties. And there is a recent case. It will be interesting when we get to it, because one public interest that was found was actually providing the information. It would give a requester the ability to be better able to determine what records to request. And so that's an interesting one I've not seen before. Steps for determining privacy interest. The first is the initial question of whether there's more than a de minimis privacy interest in the records that are the subject of FOIA requests. Absent this de minimis privacy interest, the underlying principles of FOIA would require disclosure of the records. And if you hearken to when we just started and I was making that distinction of mere embarrassment, and it doesn't mean that for privacy interest or PII to be applied, there must be something embarrassing. But I use that example because there are times when individuals will see something that is really outlandish, but unable to connect it to an individual. And so we have now made that connection with the de minimis earlier explanation. Third, if established that the individuals maintain more than a de minimis privacy interest in the records, the next question is whether there is a public interest in disclosure that outweighs the privacy interest. And this is where sometimes agencies have a problem making that determination. To establish a FOIA public interest in disclosure, the information sought will serve the basic purpose of the FOIA, which is to open agency action to the light of public scrutiny. When privacy interests are implicated, the burden is on the requester to establish that disclosure would serve a significant public interest, and that interest must be more specific than having the information for its own sake. And based on this step, that's one of the reasons why I say it's interesting that the court found in a recent case, one of the reasons is that the agency, the requester would now have the ability to better determine what records to request. Exemption 2 continues. Inability to balance the individual's privacy interest with the public's interest. DC Court of Appeal in the Fraternal Order of Police case balanced the privacy interests of individuals with the public's interest in disclosure and found that the privacy interest was not outweighed by any public interest identified by FOP. Its intended use of the information to educate police officers and defend those facing disciplinary action is a private interest of the FOP and its members and not a public interest. And so this is a contrary finding. That's the opposite side to this case that I mentioned earlier, more recent circuit court case, Texas Public Policy Foundation against the Department of State. balance the privacy interests of mid-level non-policy-making government employees with the public's interest in disclosure, and found that the privacy interest was outweighed by the public's interest identified by TPPF. And this is the one that has the FOIA being able to make a more precise request. And so to a 2-to-1 decision, the court found as follows, I'm quoting, "The department is wrong that disclosing the identities of employees who lack policy-making authority would provide no insight into government operations. Knowing the identity of those actors would help the public learn through open source research, for example, the seniority, backgrounds, and areas of expertise of those department employees who work to commit the U.S. to the goal of achieving a substantial reduction in emissions." And this is the other portion now. The department has failed to rebut TPPF's contention that having the information it seeks would help TTPF and others craft more precise follow-up FOIA requests. So that's a recent case. Exemption 4, this protects interagency and intra-agency memos and letters, including memorandums or letters generated or received by the staff or members of the council, which would not be available by law to a party other than a public body in litigation with a public body. And the federal equivalent is Exemption 5. It's a similar wording here. Provides that the deliberative process privilege shall not apply to records created 25 years or more before the date on which the records were requested. And remember the case earlier about inconsistency, where there's no inconsistency between the statute on any provision, then DC FOIA follows a federal FOIA. And so the same applies with this 25 years. Exemption 4 incorporates civil discovery privileges into FOIA. And so requesters sometimes try to get a fast one in, so to speak. It prevents requesters from using the FOIA to get documents that would be privileged in discovery. And so there are 3 aspects to Exemption 4. Deliberative process privilege, attorney-client privilege, and attorney work product. Now, what agencies get wrong under Exemption 4? The first is treat agency policy or final agency documents as pre-decisional. Have not identified a decision-making process. 3, treat a previous pre-decisional document as adopted or incorporated without the existence of express rationale for adoption. And 4, apply the consultant corollary doctrine in the absence of a consultant relationship between the government and the third party or the outsider, or where there's no common interest agreement. 5, failure to segregate factual information. Deliberative process privilege. It has 2 prongs, pre-decisional and deliberative. So it must be pre-decisional, must be deliberative for it to be deliberative, for deliberative process privilege to apply. The purpose of deliberative process privilege, encourage open and frank discussion, protect against premature disclosure of proposed policies, guard against public confusion from release of rationales that were not ultimately the basis for agency decision. Pre-decisional, what does this mean? Pre-decisional communications, they precede the adoption of an agency policy. And so you're going to address your mind to this is not after the policy. This is not after we have worked on this and we have discussed. And so for a pre-decisional element to be found, the agency must be able to identify a decision-making process that led to the creation of the withheld records. And note that final agency decision is not required. Concerning federal FOIA, courts have recognized that agencies sometimes decide not to decide. And so there are records that may be pre-decisional, but there is no agency a policy then. There is no end product to show, and whereby that end product would not be pre-decisional. But there was that process. There was that decision-making process, albeit it did not reach the required conclusion. Pre-decisional versus post-decisional. So post-decisional records are not protected by deliberative process privilege. And these are examples of post-decisional documents that reflect an agency's final position on an issue. So it's not records of the process, but the final decision concerning a specific issue. Post-decisional documents that explain an agency's actions. Why did the agency take this position? That's based on asking the question and responding to that question on the basis of the end product. Not documentation of the decision-making process, but it explains why the agency has taken a certain position. The public has the right to know about official agency position. And so we see that balancing, whereas, yes, exemptions are applicable to certain records. At the same time, the public must be able to know about the affairs of the government as long as it does not infringe upon any statutory provision or any of these exemptions that are supposed to be applied. The common thread in these two examples are post actions. They are after the decision. And so when you're examining your records, you ask yourself, is this in the process or is this after? And then you'll be able to relates to deliberative process privilege. Another thing that agencies get wrong under Exemption 4, they have not identified a decision-making process. And so the deliberative prong of deliberative process privilege. So no decision-making process identified equals no deliberative to work with. For there to be pre-decisional, for there to work, no deliberative to work with, pre-decisional, for there to be the application of deliberative process privilege. I know this is a lot, so let me explain. So no decision-making process is identified. It means that there was no deliberation, the deliberative prong has not been established, because you need that prong to work with the pre-decisional for the deliberative process privilege to be identified or achieved. So deliberative communications are offered in support of an agency's decision-making process. Deliberative process information must reflect deliberative communications. And sometimes certain words, keywords can alert you that this is deliberative communication, but you will not always find these keywords. So it's always good to examine the records properly, to read through them, to determine, because there are times when you'll have portions of these keywords, but if you read records or further up in some paragraphs or related documents, other pages, then you would have seen the conversation or whatever is being addressed continue, that there's a continuation. So albeit you aren't able to find these keywords, but excellent, if those words are there, you can move along faster. I recommend, this is my opinion, I believe. So let us move along to what agencies get wrong under Exemption 4. Another thing is to treat a previous pre-decisional document as adopted or incorporated without the existence of express rationale for adoption. So we'll explain what this means. What's adopted or incorporated? A pre-decisional document used in decision-making process by an agency will lose its pre-decisional status if it has not been incorporated or adopted by the agency in its decision-making process. And so let's, an example that, an agency has this pre-decisional document. They are working on something to put out there. They're in their decision-making process, using whatever material they have before, some that are not pre-decisional, some pre-decisional, some that they have come up with in the moment, and so are in that process. But this pre-decisional document, if it's not adopted or incorporated, it will lose its pre-decisional status because it would not have, albeit in a different situation, it was pre-decisional at this point, it would not have retained that pre-decisional status because it's not adopted or incorporated. And what is adoption? Previous pre-decisional document comes to be used by the agency as the embodiment of agency policy. And I've underlined embodiment because embodiment is a strong word. It becomes the core. It is put in, in full in that agency policy. But as we'll see that, just put it in there without more for adoption, it will not do. And how about incorporation? They're similar in a certain way, and I'll explain why I say a certain way. Because incorporation, the decision maker expressly cites a previous pre-decisional document as a rationale for the agency's decision. So it's already put in there, but the agency also cites the reason. And so it has become a part of that decision-making process. Whereas the definition we look at for adopted, it's put in there, it becomes, a whole part of that document, that policy. However, to just put it there without more, without providing a rationale, that will not do for adopted. And so you see the connection with adopted and incorporation, that in a sense, they are the same, the operator is the same. But if you're going to use adopted and you have not given that rationale, it has not formed a part of the decision-making process. And so that is key. And losing pre-decisional status. Adoption, no express approval, no pre-decisional status. Adoption of a bottom line recommendation in a document without expressly indicating approval of the rationale for the recommendation is not enough to satisfy this standard. And so that's why we are going to examine our records clearly, properly, to see whether, yes, we're aware of that record before. There was some time ago, a few years ago, there was a request and we reviewed that record, and now it's part of a few years after another set of record, and you remember it and you want to treat it the same way, but you also have to look at what has taken place, how it has been put in that record, whether it's stated that it has become a part of it. They are provided then the reason why they are adopting that record. Continuing on with Exemption 4, another thing that agencies get wrong sometimes is to apply the consultant corollary doctrine in the absence of consultant relationship with the government or between the government and a third party. So there is no common interest agreement. That doctrine has not been satisfied. So as a matter of policy, reports and analyses prepared by an organization outside the government, even if they are used in the agency's deliberative process, do not fall within this exemption. And we have our case on point here, Belth, Supreme Court case, 1987. And so what's consultant corollary? In limited circumstances, a non-agency party may act as a consultant to the government. And in such cases, their communications may qualify as intra-agency exemption for the purposes of for the purposes of Exemption 4. So who is a consultant? It covers situations where outsiders are functioning as if they were agency employees. It includes both paid and unpaid outsiders consulted formally or informally. And advice from a consultant must be coming into the agency, not from the agency. And so there's a case where the consultants, they were unpaid, and it was found, notwithstanding, there were some scientists, and it was found that they were consultants for the government. A wrong application of Exemption 4 through the consultant corollary doctrine. This case, a well-known case of Department of Interior. The department consulted with local Native American tribes on assignment of water rights. Of significance, the tribes were among many applicants for the water rights, and the Supreme Court ruled that the tribes could not be considered consultants to the department. The court explained that an outsider cannot be a consultant when the outsider is seeking a government benefit at the expense of another party. And so we must bear in mind, as it relates to consultant corollary, whether the interests of the third party. And this case, recent case, American Oversight against HHS, has provided us with this marker here. The question is whether the outsider is disinterested, whether it comes to the table with no obligation or stake in the outcome of an agency's process other than a duty to provide good advice to the agency, just as the agency's own personnel is expected to. And so when we apply this to the previous water rights case, we see that the tribes, they were definitely not disinterested outsiders. They had a stake. And so under Exemption 4, what agencies get wrong? Failure to segregate factual information. Agencies have the duty to segregate factual information. The deliberative process privilege only applies to deliberative portions of documents. So agencies must segregate out and release factual portions of responsive documents. Yes, it will be tedious sometimes, but that's the correct thing to do. However, there's no duty to segregate if the information is inextricably intertwined. Case on point, me data. Non-exempt portions of a document must be disclosed unless they're inextricably intertwined with exempt portions. And these are some sites. These are some helpful resources and also source material that I've consulted. Reporters Committee for Freedom of Press, DOJ Office of Information Policy, and Mayor's Office of Legal Counsel. We have more trainings, as I've stated when I just started. This is the first of the summer training series. And so the next training will be on July 16th, and that's the title, FY26 DC FOIA Legislation and Litigation Update. That will be presented by Anthony Skirbo, who is Beggar's FOIA Officer. And the series will continue until August 13th. It will close out with training or presentation from Assistant Attorneys General, OAG. And that session will be moderated by Director Allen. And tentatively, you may hear from Director Allen on September 10th. That would be from, as you may recall, we had earlier trainings, the FOIA training series before the summer series. And so we will see if we will inform you more as we move along with our trainings. And so that concludes. The contact information is here, staff members, and also the general telephone number and general inbox, OpenGov office at dc.gov. Please feel free to send your questions over and we'll respond accordingly. This concludes my training. Thank you. I'll stop sharing. Thank you for joining. Thank you for being attentive, and I will check to see if I have any questions to respond to. You're most welcome. If you have any questions that you did not place in the chat, please, and you'd like to ask now, please feel free to go ahead. The training material, I failed to state that earlier, will be available at open-dc.gov, a PDF version, and also the recording.
You're on mute, Anthony.
You're still on mute, Anthony.
Anthony, you're still on mute.
Sorry, Joan. There's a question in the chat regarding whether the trade secret exemption would apply to blueprints for a design for a commercial establishment.
I actually
and whether there is a need for redaction.
I actually answered that in the chat, but we can discuss it more if you'd like.
Okay, let's see. Blueprints of a design that the owner paid a private company for their establishment, that is restaurant. And you may not be required to automatically withhold the blueprint simply because a private company was paid to design them, but you must redact or withhold specific sections of those blueprints if they meet the strict FOIA. I agree with Lois. And so the blueprints of a design that the owner paid a private company for their establishment. And so the blueprints, it depends, trade secret. That requires some consideration, trades, because we have to apply the 3 prongs. We have to apply, confidentiality. So if you can't pass that hurdle, and then we can't get to the next one. We have to look at whether it's commercial And so we have to examine that and looking at based on, we have a case law, that provides the ordinary meaning of commercial. And so I don't want to give a broad yes or no, but I would prefer for us to, examine that issue based on those three. And then we have to get to, if we cover those, then we have to get to the competitive harm, foreseeable competitive harm, substantial to aspect of it. So based on just saying blueprints, design, it sounds that way because it sounds like, those we'll be able to establish those, but I just want to bring to your attention, those prongs that we look into them. So thank you, Lois, also for responding.
Sure.
So, okay, I see that someone is typing also, thank you. So I believe that there are no other questions, none in the chat, and no one is verbalizing any. And so thank you all for joining. If you have any other questions, please feel free to send them over and we will respond accordingly. Have a good afternoon all. Stay safe. Goodbye.